And that is where we are today, where Comrade Honorable Gideon Lubinda is the president of PF today. Now, from this, you'll be able to realize that all these events that have been undergone by the Patriotic Front have all emanated from one thing, where people indicated that we need a convention. But when Dr. Lungu came back, there was no need for a convention because the Central Committee itself agreed to put the convention on ice. So you see, all this has been decisions that have been made by Central Committee. And you know, Central Committee, excuse me, and you know, Central Committee of the Patriotic Front is the highest decision-making body of the Patriotic Front. And that is where we've been. So most decisions have been made by Central Committee of the party. And unlike the insinuations by certain sections of society that it has been Honorable Gideon Lubinda that has been moving or postponing this this convention or conference, it has not. Central Committee makes the collective decision, and when the collective decision is made, it is announced thereafter by the party spokesperson. The Patriotic Front political party has got two centers of communication dissemination, which is the president of the party as well as the secretariat. So, where a secretariat announces, it doesn't mean that they are the ones that have made the decision.
Let me refer to a recent case, still on the issue of wrangles, Mr. Mukandila. We've seen that despite having these wrangles with the Chabinga camp and other wrangles are now developing in the Patriotic Front, I'm referring to recent decisions, and you've indicated to say the Central Committee is the highest decision board of the Patriotic Front. But we saw recently, according to information which is out there, Mr. Gideon Lubinda, who is now the acting party president of the Patriotic Front, making certain changes, dropping certain people, senior members of the party from the Central Committee and appointing other people in those positions. And you are amongst those who were appointed after we saw Mr. Lubinda dropping Madam Brenda. You took up the position of Deputy Secretary General, of which this has been challenged. And this other camp now is threatening to take the other camp led by Mr. Lubinda, which you are part of, to court. What is going on?
Yeah, so it's extremely important for me to understand this in no uncertain terms. Very important. The Patriotic Front Constitution is extremely clear. And I think it's important that I read the provisions so that the Zambian people should see and understand. I'm a proponent of good governance and constitutionalism. I would never sit in a space which abrogates the Constitution, by the way. So I want you to understand that Article 54 of the Patriotic Front Constitution says, it provides for Vice President. It says functions and duties of the Vice President. The Vice President shall have the following powers and duties and functions. Yeah? I will go straight to D, which says to exercise the functions of President in case of death or removal from office in terms of Article 53. To exercise the functions of President. Very important to understand. Now, when you understand that the Vice President exercises the functions of President, you will go and read the provision that provides for functions and duties of President. Now, Article 61 of the Patriotic Front Constitution provides for powers and functions of President of the party. Now, in the exercise of the powers and functions of the President, Honorable Gideon Lubinda exercised the functions or powers provided for in Article 61J, which provides that the President of the party shall take a decision or an action which, in his opinion, is in the best interest of the development or security of the party.
You say President. Mr. Lubinda is acting President.
No. So I think the reason I read the previous provision was for you to understand where we are. I think let me read it again. Possibly other members of the country may be in the space where you are. Let me read this. Mr. Lubinda, before I can even read, Honorable Lubinda was acting president up until the death of President Lubinda.
Okay.
Now, Article 54 of the PF Constitution, as read, it says the Vice President shall have the following powers, duties, and functions. When you go to D, it says to exercise the functions of President in the case of death or removal from office in terms of Article 53. In the case of death, so this person now assumes the exercise of the powers and functions. So when now we don't have Dr. Lungu anymore, we now go to understanding what are the powers and functions of president. Now, the powers and functions of president are as follows. That is the article that I read to you, Article 61. And specifically, we're looking at J, which deals with the power and the function that the president used, President Lubinda.
So he did not abrogate the PF
There is no
Constitution
abrogation
by
whatsoever.
removing senior members from the Central Committee.
So the decision that was taken by President Lubinda, it was taken in accordance with J, 61J, which says, take a decision or action which in his opinion is in the best interests of the development and security of the party. So it is in the best interest of the president to have taken that decision.
So he did not need to consult the Central Committee.
Is there anywhere
I'm
written?
just saying, according to what you've read, it was in order for him to make that
This
decision without consulting the Central Committee.
This gives President Lubinda unfettered discretion to make a decision, which he thinks. It doesn't say which Central Committee thinks. It says which he thinks is in the best interest of the development and security of the party. So it's extremely important to understand. So if our colleagues will feel bad that they've been removed from Central Committee, well and good. It's been done using the discretion that the president has. Unfortunately, there's nothing you can do about it. The same way that you find President Hakainde has got the power to replace a minister at any time without consulting cabinet. He uses an authority in the constitution which has given him the discretion to make a decision without consulting anyone. It's the same authority that is in our party constitution, where the president of the party will use an authority that is enshrined in the constitution and fettered discretion upon him. So, of course, it has happened. Our colleagues have been removed from Central Committee, and it does not in any way indicate that it was a disciplinary action. No. It was a decision made by the president, which in his mind, he thought it is in the best interest of the party.
You keep referring to the best interest of the party, though some of the members feel that these decisions which are being made by Mr. Given Lubinda as the party president, they are bringing more confusion and not uniting the party at this point where everyone expects that the Patriotic Front would be united. What do you make of such sentiments?
And unfortunately, you see, a minute group of individuals who have been removed from Central Committee have given their stance that they feel the decisions made by President Lubinda are not in the interest of the party, or they disadvantage anyone whatsoever. But unfortunately, this is discretion that is given to the president. Discretionary authority upon which the president can make a decision. And it doesn't provide for anywhere where it's going to indicate that it can be questioned, unfortunately. However, it must be noted that there are sections of society that have indicated that no, there are certain individuals who apparently feel President Lubinda is putting his own people who will support him at the conference. But I want to categorically explain to you firstly the people that have been perhaps placed into the Central Committee to replace those that have been dropped. so that you understand exactly the kind of individual you're dealing with as president of the party. Lusaka province, provincial chairman. This is a person who is on record that he supported, is it Honorable Shimbakambwi? But President Lubinda decided to give him the position as provincial chairman. How selfless can one be? Provincial youth chairman for Lusaka is a person who ultimately found himself supporting Honorable Brian Mundubile in this race. But President Lubinda said, this person has been acting as youth chairman. We must elevate this person. We can't leave. Why should you bring another person to occupy the office of youth chairman in Lusaka when you've got a vice? Why can't you elevate? Everyone in positions always hope for elevation. They elevated him. He supports Lubin. I mean, he supports Brian Mundubile. How selfless can one be? Where he decides to give positions to people that are supporting his opponents in this fight. The person who's been made, there's a Central Committee member, Honorable Goodson Banda, who ultimately has come out to say he supports Honorable Makembe Zulu. But is he a good mobilizer? You see? So Honorable Winda decides to employ that person or to appoint that person into Central Committee. Okay. Why not? This is a person who's got capacity. He's proven himself. Honorable Schalo, another person who supports in this race, he supports Honorable Makembe Zulu. But the president has been asking to say, I'm making these appointments. And some people would actually tell him, but Mr. President, this person has gone out, is actually openly supporting for this candidate. He says, no, but these are members of the party. Okay. Not only are they members of the party, these are committed individuals that have proved themselves. The person who went to replace me as National Deputy Youth Chairman for the Patriotic Front and MCC, Mr. Matafwali, he is out there. He supports Honorable Chimbakambwili. So what is wrong with him identifying talent and those that have worked for the party for the longest time, devoid of this competition that is within? Remember, the competition in PF is only an internal thing. We've got better competition that we need to concentrate on, which is Hagainde and his government. But should we decide to put people that are not strong in positions simply because we are aspiring for positions? No. And that is the kind of attribute Dr. Lubinda or Mr. Lubinda, Honorable Lubinda, has shown the Zambian people. That listen, it doesn't matter. This is internal politics. We'll deal with the internal politics. But at the right time, we must ensure that the party remains strong. Okay. I mean, I have been given the appointment as Deputy Secretary General.
Do you deserve that appointment?
I feel I have earned it, as a matter of fact. So, that is where we are. Let us not politic just for the sake of politicking. Does Honorable Lubinda have the authority to do what he did? Yes, he has. Can he remove anyone from Central Committee? Yes, he can. Does he have unfettered discretion to take up those moves? Yes. If he feels it's in the best interest and development of the party, why not?
Okay, thank you, Mr. Mukandila. Talking about, still on the issue of internal conflicts, my next question would be, now that you are Deputy Secretary General of the former governing party, what concrete steps are you taking, or are there any steps being taken to bring together the rival factions, including the Chabinga camp, whereby matters, whatever is going on in court, can be resolved out of court? Like you have stated, to say the idea is for the former ruling party to be united so that you can challenge or face the current governing party. Are there any steps being taken to reconcile outside court?
First things first, as we look at the idea of reconciliation, we should also look at the idea of discipline. Personally, I will tell you I'm a disciplinarian. I want to ensure that the law is followed to the letter. I want to ensure that constitutional provisions are respected. I want to ensure that the integrity of the party is not brought into disrepute at any point. So for me, I'll tell you, I'll maintain a disciplined move, a disciplined mode of management. As you are aware, the Secretary General is the CEO of the party, and being one who is occupying the administrative base as Deputy Secretary General, I must ensure that the admin part of the party is intact. So first things first, we must at all costs ensure that there is discipline. Discipline entails that members of the party must be able to respect all sections or levels of leadership within the party. Very important. From there, then we move to the next stage where we'll look at, okay, fine, how best do we then reconcile these members? Now, in the process of reconciling the members, we must be able to ensure that they are disciplined. Extremely important. For example, we had sentiments that were made just recently by Honorable Davis Mwila. Sentiments that bordered on tribal divides, sentiments that bordered on racial discrimination, sentiments that bordered on bringing the party into disrepute. Now, does the Patriotic Front support such sentiments? We don't. Do we have to ensure that the correct measures are taken? Yes, we must ensure that is done. So it has to start from there. Do we feel will eventually emerge victorious as a united Patriotic Front? The answer is yes, and the reason is simple. For the last 4 years, the Patriotic Front has been held strong and firm. All structures are intact by Honorable Given Lubin. For the last 4 years. Realistically, no structure of the party has ever defected to the ruling UPND. That is a reality. Okay. We have all the structures, and that is why we actually even indicate that the Patriotic Front is the biggest political party in the country. Not even UPND can match the strength and prowess of the Patriotic Front. We are the biggest political party in the country. We've got structures on every polling station in this country, realistically speaking. And these are structures which we can actually get in touch with anytime, any day. Okay. So,
you can finish your thought.
Yeah, so from there, we can be able to advise and engage and indicate that the Patriotic Front has remained a united force. The unity of the party is shown by the strength of which we have not defected in any way. Yeah.
And you said are there, I don't know, maybe I missed your point about ensuring that you bring even the Chavinga camp and the other camps together so that you can resolve matters out of court. Yes, I know you've talked about the issues of discipline, but is that being done or not?
Yeah, so in terms of engaging, there's nothing wrong with engaging, and we've been engaging, we've continued to engage, and we are very hopeful that the engagements that are underway will eventually result into fruitful results, as a matter of fact. I mean, we emulate the character and nature that the former president, Dr. Lungu, had, may he so rest in peace, of ensuring that even those that offend us today must be forgiven tomorrow, and we must work together as one, in unison. Yeah.
Talking about discipline, when you were talking about discipline, you cited an example of the former Secretary General, Davis Mwila, concerning the recent remarks he made against the current president of the party, Mr. Lubinda. What disciplinary action have you taken, or what is it that you're doing to ensure that indeed that discipline you referred to is maintained in the party? Are you taking any action as a party against him?
The Zambian people shall be guided on that one.
Okay.
Yeah.
Now, Mr. Mukandila, let's move to another issue which has been trending, and this one benefits all Zambians, the constitutional making process. And in this case, I'm referring to Bill 7. You took the government to court in the Mukandila Monia Zulu case, And we saw at some point the Constitutional Court wrote that that process then lacked wide public consultation, and the whole process was declared illegal and unconstitutional. After that, a few weeks after that, we saw the government coming up with a technical committee to receive submissions from the Zambian people, and they went around the country to receive submissions in regards to the constitutional making process. So while Bill 7 then was put on hold in Parliament, but we saw last week Deputy Speaker of the National Assembly announcing to say they had received communication from the Justice Minister to resume with the process. After that, you went back to court, you challenged, saying that whatever was happening before the House was contempt of court. And a day ago, the Constitutional Court ruled against that, whatever you had filed before it. How do you make, or what is your position when it comes to whatever is going on as far as the constitutional making process under Bill 7 is concerned?
Okay, well, government decided to unilaterally commence a process to amend the Constitution. By unilaterally, we mean the government decided on their own without consulting anyone. Probably President Hakainde sat in his cabinet with his colleagues and just said, gentlemen, let's just amend this thing. And they agreed and came up with terms of references, or is it provisions? They even came up with a bill. Unfortunately, we told them that that position you've taken does not live up to the spirit of the Constitution and therefore abrogates the provisions of the very Constitution you are trying to amend. They decided not to listen, but we decided to undertake a process by using all legal means to provide the relevant checks and balances. We went to court to challenge the process upon which the government initiated the amendment process. And the Constitutional Court ruled in our favor by indicating that the process does not live up to the aspirations of the spirit of the Constitution. Now, if I may just go through paragraph 55 of the judgment of the Constitutional Court, where the court indicated, as I quote, that having considered the Constitution as a whole, in particular Articles 1, 2, 5, 7, 8, 9, 61, 90, 91, 92, and 118, we have come to the inescapable conclusion that the Constitution amendment process cannot be initiated without the participation of the people of Zambia through wide consultation. The court went on to state that in the absence of any evidence that the initial process undertaken by the respondent meets the expectations of wide consultation with the people, as stated above, we are of the firm view that the initiating process lacks legitimacy. Now, that is what the court indicated, that the initiating process lacked legitimacy, and therefore, when something lacks legitimacy, what does it do? It lacks legitimacy because it is against the provisions of a document that would provide the relevant legitimacy. The court now gave the following relief by indicating in one, that we declare that the decision by the respondent to initiate a constitutional amendment process before undertaking wide consultations with the people goes against the spirit of Articles 1, 2, 5, 7, 8, 9, 61, 90, 91, and 92 of the Constitution. It went further to give another relief, that we order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body of experts in conducting wide consultations with the people. Now, having ruled like this, it simply means the court indicated that the process was unconstitutional. It went against 10 provisions, is it 9 provisions of the Constitution, as I indicated or as I listed. those provisions simply meant that this president who initiated the process abrogated the constitution by going against those provisions. And the court guided to say it must go to deal with the spirit of, it must comply with the spirit of the constitution. Remember, what we are looking at is the process upon which that bill was made. If the process was wrong, it means the entire bill should not even be looked at twice.
Okay.
That is the reality. So the process was wrong, don't even look at the bill. The process was unconstitutional, don't even look at the resultant cause. That is what the court said. Now, the court guided to say you must comply with the spirit of the constitution. What is the spirit of the constitution? The same judgment has guided also that in paragraph 51, it says, in our considered view, the TCDZC, which is the Technical Committee on Drafting the Zambian Constitution process, yeah, should be replicated or something of similar magnitude, pursuing the process that was used by the Technical Committee on Drafting the Zambian Constitution should be initiated, wherein it goes on to say, and this is very interesting, and I wonder what our colleagues have been doing. He said they've just not read this judgment, they just went on to do their own things. It went on to say, it constitutes what we understand to be wide consultative process to alter the existing content of the Constitution. Now here the court gave the definition of what they understand to be wide consultation.
So they guided to say a technical committee should be formed to involve the Zambian people through consultation.
Now that technical committee should be one that is similar or a replica of what was under the Technical Committee on Drafting the Zambian Constitution. That committee, remember that one? Yes. It should be a replica. Now that replica, how was it formed? How was it made? How was it appointed? That is where now we go back to the appointment. We are trying to create a replica of this technical committee. How was it appointed? First things first, the President of the Republic of Zambia used the Inquiries Act to appoint that technical committee. The Inquiries Act appointed the technical committee. And that technical committee, by use of the Inquiries Act, provided independence in the committee. That is what is very critical. Remember, the relief, the court said there should be an independent body of experts. It provided independence. Independence entails that this committee should not be subject to the control of anyone.
And
it should operate independently to the extent that they would just ensure that they follow what we call terms of reference.
And one would argue to say, we saw that taking place. We saw President Hakainde Hichilema making appointments, and the technical committee was formed, which even went round the country, got submissions, and according to the records, they received over 11,000 submissions from the Zambian people. Does that not really speak to what you're referring to?
That is where I will ask our colleagues to read the judgment in full. The judgment said it should replicate the process. When you replicate, what does it mean? It means it has to be similar or congruent. You get it? Now, for it to be similar, it has to start from the appointment. What law have you used to appoint this committee? For it to be similar to the Technical Committee on Drafting the Zambian Constitution. The law that was used is the Inquiries Act. Did President Hakainde Hichilema use the Inquiries Act? No, he didn't. This committee is supposed to be independent. Was this committee independent?
When you say independent, what?
And I will tell you what it means. It means when you use the Inquiries Act, the Inquiries Act has actually provided that any committee or any inquiry, commission of inquiry appointed by using this law will give that commission independence. So that is the independence we're looking at. So there's a legitimate expectation that has been created in constitution making processes. Now, when you are told that it has to be independent, don't go out there and appoint a committee that will be under the control of the executive, or under the control of the judiciary, or under the control of the legislature. No, it should be an independent body. You get it? The only thing you do is give them terms of references as to when to be done with the work, how far they should stretch, and what they must do. Now, what they must do is consultation with the Zambian people to come up with a bill. Provisions have to come from the Zambian people. Proposals have to come from the Zambian people. Did this committee have independence? It did not. The reason is simple. That committee was appointed by the use of Article 92 of the Constitution. By the use of Article 92, and specifically they used Article 92(2)(f), which says, without limiting the other provisions of this Constitution, the President shall appoint persons as required to perform special duties for the executive. This provision, Article 92, provides for executive functions of the President. Now, they are supposed to provide executive functions of the executive. It simply means that they were not independent. They were performing an executive function for the executive. So we need to be very realistic and look at these issues without thinking twice about it. No. So what our colleagues did, the moment they decided to say we are appointing a technical committee, I saw, should have been Honorable Samba even went to court to judicially challenge that decision, because it did not live up to the spirit of the Constitution and the guidance of the Constitutional Court. Furthermore, the moment we saw that our colleagues decided not to withdraw Bill 7, I went to court with my good comrade, Honorable Munir Zulu. We commenced contempt proceedings against the Speaker of the National Assembly and the Minister of Justice. Now, this is where now I want to clarify certain issues. When we commenced contempt proceedings against the Minister and the Speaker, what we were contending is that our colleagues should have withdrawn the bill entirely, because according to the guidance of the court is that that bill was not formulated in accordance to the spirit, with the spirit of the Constitution. What does that mean? That Bill 7 is unconstitutional. Don't even deal with it. Do not even touch it. What you must do is to withdraw it entirely. Do not use semantics by using words such as deferring. Don't defer it. Withdraw it entirely. And that is what we were contending when we took the Minister and the Speaker of the National Assembly to court for contempt proceedings. Now, the moment we saw a committee being appointed and Bill 7 being brought back on the floor of the House, remember we already have an action against Minister and Speaker, which is active. The moment we saw the committee being formed, we knew to say the entire National Assembly will now be dragged into discussing an unconstitutional Bill 7. One that ought to have been withdrawn from the floor of the House. And that is why we undertook a decision to take the entire National Assembly to court for contempt. Now, there was a bit of a dereliction on our part as lawyers on the law that we used to add those colleagues.
Okay.
We used the provision that provided for interlocutory applications. Now, interlocutory applications are applications that are done or that are made within the course of the matter. It was a dereliction on our part as lawyers, and we accept that, you know, and that is why the court guided.
Your case was dismissed based on what you're just explaining.
Yes, not the case. The application to add those colleagues. Yes, that is why the application to add those colleagues who are members of Parliament was dismissed, because we used a law that dealt with interlocutory applications. However, it did not go through to dismiss our other contempt matter against the Speaker and the Minister.
So
it is still very active. It is still very active. I was even surprised to see Speaker celebrating or intimating to the National Assembly to say we should actually celebrate. There's nothing to celebrate.
There is an active matter in court concerning the contempt case.
Yes. Minister of Justice and Speaker are still in court.
Mr.
And we are
Mukandila.
hopeful that by Friday the court may give us a date for a full bench to listen to this matter and perhaps make a decision.
From what you've explained, it seems like the only problem you have, and I think this is what other maybe people are saying, it is about the process. Is it just about the process or the content in Bill 7? If we speak to the content, what is it that you're pointing to say this should not be part of Bill 7, or you're not just satisfied with the process and not the content of the bill?
I think everything must start with the process. And I want to give a very practical example so that you understand how serious a process must be taken. The same matter you are mentioning about the content, the court actually indicated to say the process we undertook was wrong, and they threw out that application. It's a process. The same way that the court indicated that the process that was undertaken by this government to initiate Bill 7 was wrong. Bill 7 was thrown out of reality. It's in the gutter. It is supposed to be considered unconstitutional. We shouldn't even talk about it, for starters. We must not even talk about it because it was unconstitutional and it's a wrong process that was used. So now, dealing with the content, for me, I will actually tell you that I have never, personally by the way, I have never even comprehended thinking of amending the Zambian constitution in its current form. And the reason is because the constitution has not been fully tested.
Okay.
By fully testing, I mean, if there's a provision that anyone feels is producing a repugnancy, a provision that anyone feels is producing an inconsistency, a provision that anyone thinks or feels is producing any form of inconsistency in the interpretation, what that person is supposed to do is to go to the Constitutional Court, take that provision before the Constitutional Court for interpretation. In this constitution that we have today, the Act number 2 of 2016, it has not been fully tested. And the reason why it has not been fully tested is because provisions that these colleagues are indicating they need to change or amend have not been taken to court for interpretation. Until such a time when they interpret those provisions, will we say, colleagues, these provisions have been found to be wanting or problematic, can we amend them? Now, this Bill 7, and I want the Zambian people to be very categorical when dealing with this thing. This Bill 7, when we want to look at that, the same content as you would want to put it, you want to talk about delimitation. These colleagues don't even understand what delimitation is according to Article 58. Is it 58 of the Constitution?
What does it state?
Article 58 of the Constitution is extremely categorical, and of course it provides for delimitation. Yeah, it provides for constituency and ward delimitation. It says Zambia shall be divided into constituencies and wards for purposes of elections to the National Assembly and councils respectively. It goes on to say the number of constituencies shall be equal to the number of seats of elected members of parliament. Now, when you read this provision, there's another provision that provides that there shall be 156 members of parliament. Yeah? So now, understand this. It goes on to say, the Electoral Commission shall determine the names and boundaries of constituencies and wards. The Electoral Commission shall, at intervals of not more than 10 years, review the names and boundaries of constituencies and wards. You get it, huh? At no point does it say it should go and delimit or divide constituencies. No. It's talking about reviewing the sizes or the boundaries of these constituencies and wards. You have 156 that is provided for in the Constitution. In terms of delimitation, all that the Electoral Commission of Zambia is supposed to do is, there are those provisions that have been given to them. There's a delimitation report which is supposed to actually be made public to the Zambian people. That report is supposed to indicate which constituencies deserve to change in terms of stature, in terms of size, in terms of the boundaries.
And that report,
and not dividing the constituencies. It is the changing of the size and the boundaries. And then now, the process of changing the boundaries would also entail that those constituencies where people will have submitted that these constituencies are too big, what you do in order to equitably distribute resources, what you do is, if Matero constituency has got 5 wards and you feel it is too big, the only thing you do there is add the number of wards, delimit the number of wards. If they've got 5 wards, add them to 8
within
wards.
Matero.
Within the same Matero
Not that
constituency.
Matero should be Matero North and Matero
No.
South.
The constitution is very clear and it guides exactly how it should be done. When you divide it by way of ensuring that you delimit the wards, if there are 5, make them 8, so that in terms of distribution of CDF, which is a fund provided for in the constitution, you shall distribute equitably, because CDF is run or managed by the local authorities. So remember, we came up with devolution of power.
Mr. Mukandila, because when it comes to that proposal you've referred to, the executive is saying, looking at it, that certain constituencies are too vast and every constituency is getting similar share when it comes to the constituency development fund. Hence, certain constituencies are being disadvantaged. This is the reason why government feels that the constituencies which are too vast should be divided so that that development can be brought closer to the people. What's wrong with that?
The problem is our colleagues don't read. They don't read. They must go back and read what the Constitution says with regards to delimitation. And the reason why the Constitution actually provided for delimitation in that way, the reason why the Constitution provided for delimitation in that way is because when you look at those constituencies that are extremely vast, what you do is you just ensure that you delimit the number of wards. The Electoral Commission of Zambia can actually do that every 10 years. The Electoral Commission of Zambia can actually do that every 10 years.
Okay.
And every 10 years, you can look at this constituency. Okay, Kanchivia is too vast. What can we do? Colleagues, we want equitable distribution of fund in Kanchivia. So it's got 10 wards. Let's make them 15. Or perhaps let's make them 8 wards, but the size of the constituency should be reduced. The one that has to be big thereafter is the neighboring constituency. So you change the boundaries of the constituency. And that is what the law provides for. You don't need to divide the constituency. The law is very clear. The drafters of the Constitution were very elaborate. And now you see why I say our colleagues don't read. It's very funny that they would sit in those offices with air cons and not really do the correct job and advise this president correctly. When you look at Article 62, remember just now you are talking about equitable distribution because they are all given equal amounts.
Yes.
When you look at Article 162 of the Constitution, it provides for the same fund which is called the Constituency Development Fund. Article 162 says there is established the Constituency Development Fund. It goes on to say the appropriation of monies of the Constituency Development Fund and management, disbursement, utilization, and accountability of the Constituency Development Fund shall be prescribed. Now, the Constitution says the utilization, the appropriation, the distribution shall be prescribed. It does not provide that it shall be prescribed and it shall be distributed equally. No.
So you're saying
These colleagues, listen, that's what I'm telling you, they don't read. There's a constitution, I want them to start reading these things. What they should have done is to just agree to say, colleagues, this constitution has provided for this fund called CDF. This constitution has provided that CDF shall be prescribed. So what do you do? By prescription, it means there should be a subsidiary legislation to provide for CDF. The prescription in terms of distribution, you can actually agree to say, we are not going to give constituencies equal amounts of monies. Some constituencies are too big, others are too small. Some are in urban areas, others are in rural areas. Though there are some that have got huge populations and others with minimal populations. So what do? Let us distribute according, for example, we create a benchmark according to the number of people in the constituency. Let's distribute according to the size of the constituency. Let's distribute according to the development agenda, the development that you can see in the constituency, in terms of infrastructure, in terms of schools, in terms of all those things. You can do that. So you don't need to divide these constituencies. You can agree that Matero, since it's got 5 wards, give it 30 million. Kanchivia, since it's vast in size and it requires more money for it to develop, to reach the extent of Matero, give it 60 million.
okay.
For Mwembeshi, since it's this and that, give it 20 million. You can actually do that. The constitution has not provided that you can only just give 40 million across the board. No, it doesn't. That's why our colleagues must be reading. Let them advise this president correctly.
Okay. And lastly, Mr. Mukandila, looking at time, our government also has maintained to say when it comes to the issue of Bill 7, no retreat, no surrender. What government spokesperson yesterday stated, Honorable Cornelius Mwitra, was that there shall be no going back on Bill 7, and those who have gone to court to challenge and stop the progression of the proposed constitutional amendments, including opposition political parties, as well as civil society organizations, are just wasting their time and abusing court processes. And the executive feels that at this point, why not just let Parliament decide on the bill? Unlike you people always just rushing to court, because there are numbers in Parliament. If they agree to the bill, they'll vote for it. If they do not agree, they'll not vote for it. Why not let Parliament decide?
Honorable Mwetwa should know better is of counsel. You cannot stop people from going to court. I think for me, I would tell you that the statement that was made by Cornelius Mwetwa yesterday is complete and total lawlessness in a democratic dispensation. It's lawlessness of the highest level. You cannot stop people from going to court and challenge a process they feel is illegal. You cannot stop people from ensuring that they provide checks and balances. And besides, he indicated that no, we don't have any clause in court with regards to this. Bwana, don't be too sure. Let them check the records. We've actually gone back to court with the correct law to challenge again, to cite those colleagues for contempt. So they shouldn't be too sure. I'm sure by now my lawyers have even filed into court those applications. And besides, you can't say no retreat, no surrender. Advise the president correctly. That is what they have to do. Let them tell this president the truth. The reason why, and it's extremely important to understand, you know, lawyers, and this applies to Cornelius Mwetwa also, lawyers swear in 2 oaths of office. One, the oath of office to protect and defend the Constitution. The other one is the oath of allegiance to the president. Now, the oath of allegiance entails that you must tell the president the truth and correct him as and when he makes a mistake, as and when he abrogates provisions of the Constitution, as and when he makes decisions that are not in line with the Constitution. And that is why lawyers have risen and told this president to say, Bwana, what you are doing is unconstitutional. We are in court today because this president doesn't listen. We tell him he doesn't listen. What do? We only have one avenue: to use all legal means by going to court. Today, as it stands, as we are today here, I'm actually in court with Honorable Brian Mundubile challenging the eligibility of President Hakainde Hichilema next year to contest the elections. And the reasons why we are challenging that is we are asking the court to tell the Zambian people whether a person that has violated the provisions of the constitution, as was espoused in the case of Mukandila and Zulu versus the Attorney General, where the court indicated that 10 provisions of the constitution were violated, can that person qualify to file in a nomination to contest as any position which is provided for in the very constitution they have violated? That is the question we're asking the court. And according to us, we feel any person who violates the constitution does not deserve to be in that house called State House. Any person who violates the constitution does not deserve to be occupying any constitutional office. We don't feel so. And we don't believe it is correct for them to occupy that. So we've taken the matter to court. We are hoping for the best from the court. But you'll see the gymnastics this government has started taking, having realized their failure to advise this president correctly. One, they want the court to revisit its decision in the Mukandila case. Why do you want the court to revisit its decision?
Before we divert to the other case, so, my question was, why not let Parliament decide on Bill 7?
So the process of Parliament deciding, and I want you to understand what the judgment of the court said. The court guided to saying you can only get to a point of going to decide on that on the process in the National Assembly after you complete the process of ensuring that the process lives up to the spirit of the Constitution. Period. And that is all we are asking for. The only time these colleagues should revert to using the process under Article 79 is after they satisfy, and in fact, let me just read the provision of the judgment. Paragraph 50 of the judgment says, most importantly, these processes are the source of the Constitution. To demonstrate, the Constitution of Zambia, as amended by the Constitution of Zambia Amendment Act number 2 of 2016, our current constitution, was birthed by the initial process led by the Technical Committee on Drafting the Zambian Constitution. It was a process, not the subsequent process under Article 79 of the Constitution, that framed the amendments that became the current Constitution, and their legality and legitimacy have never been in doubt, despite the absence of specific constitutional provisions. So, in essence, we must agree that the court guided that it is not the process that is provided for in Article 79, which is strictly limited to the Constitution, to the National Assembly, which must be used to amend the Constitution. But we must go beyond and look at the real issues of trying to ensure that, one, there's consultation. That way you provide the relevant legitimacy to the Constitution for it to have to stand the test of time.
And they would argue to say they've done that. The technical committee went around the country.
I've been speaking for the past 1 hour, explaining exactly what they should have done. Exactly what they should have done, and not what they have done. What they should have done, and not what they have done.
Okay.
Exactly.
Okay, our dear listener, looking at time, we'll pick, I think, just 2 last calls. My guest has to leave early, and the number is 0962-870921, 0962-870921. Millennium Radio, good morning. Good morning.
And which one?
And Angela calling from Garden Road. Vagesti vatu mukamba bwino maningi. Deswa muona patika pama radio apakuti PF inasemeza bwino maningi zani UPSD government. Mayona iyo Bill 7 ene bayumirira bamwetwa. Sibafuna verera ife Mazambiani because it's a promise Bill 7 bamwetwa na government yao wana promise kubosiriza road shading na cost of living. But mkaona bane bichibika hapa wakangiwira kwa abantu. So vagesti nimwapitirizani sebenzesani pe hope ya tulifani mwa PF wa Tonsa Alliance because mwa experience aba bantu betengo baita kota mtito na mwana wakabwera mu governance yao bataona kuti bakangibwa si bantu wo trust anafuta desa kamba mu 2026 baenda ifuna imwe na government ya mbwe mu ruling ebwino ziko.
Okay, thank you so much. We pick another call 0962870921 0962870921 0962870921. Millennium Radio, good morning.
Good morning, Wapeska. How are you?
Fine, thank you. How are you?
I'm very much fine. Good morning, Honorable.
Good morning, sir.
This is Mr. Soko calling from Tendere East. Honorable, chikuru maningi mazambia nila PF to be coming back in power. Nichonela kuti PF mtasenezedweti na yao na mpaka na manje tukwa nikakusonda. So what you need as people supporters of PF, please, imwe bantu gwiriza nani tufuna msogoleri wamine azati sogolera mu 2026 amina kala ngina mu ballot paper kuchita challenge ba echechi singa ngale 4 years checking tingala 4 years without order apa now ngani 300 kwacha. So please repeat panchina kutane bakalira bantu ifuna imwe. So ayo marongo yonza na citizen party ya Chavinga ayumira kukana mapepa yake. Just leave him, please. We see Chavinga na mapepa yake. You just do other party yonera kuti mugwirizane mulatedete tu huyu niye waPF ngati MZ8 akapita mgonjwa.
Thank you.
Thank you.
I'll pick my last call. Hello, good morning.
Good morning, Wapriska. Mwashubuka shani.
Empire Mashbuken.
Mkwai. Council Mukandila, good morning.
Good morning, Madam Mumbipiri.
Mkwai wa DSG. Ine Mumbipiri kuno kuchongwe. Council, me, I'm getting confused. Now I want to hear your comment as a legal brain. Nalala ndamuchibemba, hakutina bambi bomfweko.
Mkwai.
Ekonde fulunga nina kwebati badi chita revive Bill 7 mu parliament but later ba Cornelius Muito baisa ebechalo as government spokesperson ukwebati yadi amasabu mission ba mshabati ba pere ba president Tabaraya chita submit mu cabinet because you know for night ngaba chita submit ku cabinet every white paper if we roll kufuma. Are you telling me, is it making sense to you ukwebati if you select committee ganeri multi basontere ku parliament aba lero lisafari Bill 7 ayo ba Concord balandira it was illegal after you and Mundiazuru mwatwalo mulatu kukonti. Useko yachira panga sensi of these people are abrogating the constitution with impunity to never dama.
Okay, thank you so much, ma'am.
Thank you.
Thank you. Let's try. At least let's try to use Nyanja now or Bemba.
Okay, so monga veva kambira wa Madam Mumbipiri kufunza ati inkani ya constitution ba government boma inaenda mukutenga ma views ya bantu yaja ma views after batenga wanapanga report nomba ila report bapangire what we are being told is ija report boma ikadibo kuyamba kuyanganirapo but wachita revive Bill 7 yani constitutional court nakamba ti Bill 7 ili illegal ili unconstitutional sifungano iyangana but boma ntota ya boma ino yasta decide kuyambo yanganapo pali Bill 7 manje nanga drama zevana usinga kwendo tenga ma views vaja kuti batenge chi report chano chipakinga chabe no chiusinga manja pa kuli select committee aba speaker ija zijandrama sisa za Mazambians. Why are they talking about prudent management of resources when They have used money, collected views, they've got a report, and now they are saying that report has not been submitted to cabinet. But when you look at the terms of references, that's why I'm saying this government is a wrong government. It's a government that is extremely wrong, that they are abrogating the constitution at will. And we need to tell them off. There is no way you can get the Zambian people's money, my money and your money. Mwapangisha report. Ila report mwaisa iparking anomba pama shelves. And yet the terms of reference said, go and collect views on how to come up with a bill, and come up with a bill. That report that they had was supposed to be converted into a bill, considering what the people suggested. And that is the bill that they were supposed to present to the National Assembly upon following procedures, because the bill has to be gazetted. 30 days gazette and all that, and then place it on the floor of the House for first reading. That is what was supposed to be done. What they have done is to lie to the Zambian.
I think Mr. Mutwa said when it comes to standing orders, a government is not allowed to take back another bill during this session, or maybe until before Parliament.
So why do they want to do the wrong thing? The wrong thing they are doing is to reuse Bill 7, which is unconstitutional. The only way they can take back another bill is next year. Time has gone, colleagues. Let's accept that na muchelwa. Ani mwali sanga isi tuletea. Masanga tuletea. We've told them the right thing to do now is that report was supposed to be reduced into a bill. Why haven't they done it? What they are trying to do is to rubber stamp
for that.
But you can't say there's no time for that when Bwana, constitution making is not making rules of how to drink tea in Hainde's house. No. It's not. Constitution making is a serious process. Cornelius Mutwa should know better. President Hainde should know better. It's a serious process. You went out there, people collected views. You even bragged to say for the first time 11,000 views. Now those 11,000, reduce it into a bill. Advertise for 30 days into the Gazette. You can't decide that you go back to an unconstitutional provision. No. That is why we've opted to say we shall continue with our contempt matter. We shall hold these colleagues in contempt. And I can assure you, they think it's a mundane exercise. I'll assure you that for the first time in the history of Zambia, we might have a serving Minister of Justice and a serving Speaker going to prison for contempt.
Okay.
We must start respecting the Constitution of the Republic.
So, in short, even you are saying no retreat, no surrender on your part?
No retreat, as long as I have placed it on record that I shall defend and protect the Constitution of the Republic of Zambia, even if it meant with my life.
Okay.
I have said that and I will do it. Even if it meant that I will use my last resource to ensure that Zambia does not deviate into a dictatorial state or a dictatorship state, or where we don't give those in authority power that they feel they are gods. No one is a god. We are not omnipotent. There is only one God that is identified in the Constitution of the Republic of Zambia in the preamble.
Council, thank you so much for making it this morning.
Thank you very much for having me, and pleasant morning.
Okay, our dear listener, sadly we have to end the program, but thank you so much for listening. It is the interview program on Millennium Radio. My guest, lawyer as well as Patriotic Front Deputy Secretary General, Council Celestine Mukandila. My name is Priska Lumingo. Thank you so much for listening. Keep on listening to Millennium Radio, the voice of development. Good morning.